Welcome to Precision in Practice, Mastering Discovery in Catastrophic Trucking Litigation. I'm Belinda McCauley. I am the CEO and Executive Director of the BHBA, and I am delighted to be here this morning to introduce our speakers. Bobby Reagan is an attorney in the LA office of Panish, Shea, Ravipudi LLP, specializing in catastrophic personal injury and wrongful death. He joined the firm after 9 years in practice litigating catastrophic injury cases. He is admitted to practice in California, Washington, and the U.S. District Court for the Central District of California, and has argued in courts of appeal. He has recovered tens of millions of dollars from insurance companies on behalf of his clients. Dustin Thordarson is an attorney also at Panish, Shea, Ravipudi LLP, where he represents individuals in complex personal injury, wrongful death, and product defect cases. Since 2021, he's secured more than $100 million in settlements and verdicts for his clients. Throughout his career, he has focused exclusively on catastrophic PI and wrongful death cases, handling matters involving burns, amputations, spinal cord injuries, orthopedic injuries of many kinds, and brain injuries. So now let's get started and learn a lot from these two experts.
Thank you, Belinda. Good morning, everybody. I'm going to start by sharing our PowerPoint. Welcome to Beverly Hills Bar Association. As you heard, my name is Bobby Reagan. I'm here with Dustin Thordarson. We're here today to discuss some strategies for litigating trucking cases. So here's our contact information. Please reach out to either of us or both of us with any questions, or if you'd like copies of things that we've discussed or samples. And so...
Right, real quick, I just want to say thank you to the Beverly Hills Bar Association for inviting us to come and speak on this issue. And Bobby has largely done most of this PowerPoint presentation, so I got to give him props, and we're going to dive right in. Okay, guys?
Yeah, so we wrote an article together, Dustin and I, about discovery in trucking cases, and how it's a completely different animal from other auto cases. And so this presentation sort of builds on that. We're going to talk about some basic aspects of truck cases, discovery, regulations. For a lot of you, it's probably just a refresher course, but hopefully for some beginners, it's a good starting off point. So the first thing that I think is really essential in any catastrophic trucking case is the Federal Motor Carrier Safety Administration's website. They maintain the electronic record system. That's a website with all sorts of important details that you need in these trucking cases. And so all sorts of companies are listed here in the SAFER system. If it's a motor carrier or a company with a U.S. Department of Transportation number, then it's going to be tracked in the SAFER system. And so in California, Caltrans requires commercial carriers to obtain a US DOT number. And so all of those carriers will be listed in this SAFER system that anybody can access. And so as you see in the slide, there's a lot of really great information that you can access just through this publicly available website, carrier identification. So this is not only the legal name of the motor carrier, but it's also the DBAs. There's crash data, which shows, I think it's updated weekly lately, the number of fatal crashes, the number of injury crashes, even towaway crashes. All that crash data is included. Safety ratings. So these are audits that the FMCSA performs on and off site. And so you get to see, is the carrier unrated, which tends to be a lot of carriers. If the FMCSA hasn't actually performed an audit, it'll just say unrated. Sometimes it's hopefully conditional or satisfactory. Satisfactory being the highest rating, conditional or unsatisfactory are the various ratings within these safety ratings that the FMCSA includes on the SAFER website.
And just real quick, this is so critical when you first get retained on a case, because all of this information is free, right? And what do we care about when we're looking into whether we want to take a case on or get involved in a case, right? If there is a motor carrier involved, depending on the size of the motor carrier, depending on the insurance coverage, and depending on the goods that are being hauled, you might have several very viable defendants, but the first one that you're going to really get a grip on is typically the motor carrier if it's a motor vehicle collision. So you can look up authority history, which is what Bobby referenced earlier. This is the authority granted by the United States government to this motor carrier to do business and engage in interstate commerce. And so as a result of that, you literally just put in the DOT number, and there's all this information that you can then use in the course of developing your discovery plan in terms of what you're going to do and what you find out, so that you know already, how bad are they? Are they a good motor carrier? Are they getting in a lot of accidents? Are they getting put out of service all the time? Those are the things that matter, because if you see those are red flags for a carrier that's really not very safety conscious, or they're trying to cut corners on maintenance costs, and that's why they're getting out of service all the time. So it's a very, very helpful informal discovery tool that costs $0, that will give you a ton of information to inform you before you file suit.
Yeah, I think that's a really good point, Dustin. Just the fact that you can do all of this stuff without hiring an expert or spending much money on the case. So the SAFER system is a great place to start, but there's all sorts of other things that the federal rules require motor carriers to hold on to create records and maintain records for statutory periods of time. And so we have a list of some of them here. So driver qualification files. These are required to be kept by the federal rules. They've been adopted in California. So even intrastate carriers in California have to comply with a lot of these federal rules. And so carriers have to hold on to these records for the entire time that a driver is employed by the carrier, plus 3 years after, at a minimum. And so, we have here like medical certifications. I know Dustin and I have talked about this a lot recently. Department of Transportation physicals can be a really interesting source of information in a case. If a DOT physical form has a driver saying that he drinks 3 to 4 drinks per day, 3 to 4 days per week, that information can be cross-referenced against his hours of service to show that he was almost certainly drinking on the job. There's also some disqualifying medical reasons that drivers shouldn't be employed, or that make them more susceptible to fatigue or causing crashes. I know Dustin had an issue with a medical certification from a DOT physical recently.
Yeah, so this is a good part for me to segue, because Bobby is brilliant, and I like to talk about the things that I do every day. And so a recent memory for this, really the driver qualification file in its entirety, but in any trucking case, if you do not receive in a production of documents these basic things, like the driver's history, I think it's a 5 or a 7 year window that they're required to provide when they get hired by the motor carrier. That will show any moving violations on the commercial CDL, the commercial driver's license. Also, it will show whether they disclose the existence of any speeding violations, moving violations, and what due diligence did the motor carrier exercise when they hired them. Because what are we all trying to do? We're always trying to establish concurrent negligence of multiple tortfeasors, because that's how we can essentially maximize or do our job to try and maximize our client's recovery. So when you can demonstrate that, for example, in a case that I had where the driver was hired, he handed the motor vehicle record to the human resources representative, and she just didn't even review the fact that he had 2 speeding violations on his motor vehicle record. Now, he also was on metformin, gabapentin, several other different medications that he did not disclose in his to the examiner that certified his fitness to operate a commercial motor vehicle. And so I then established all of these things when I cross-examine the person most knowledgeable at deposition, and you show that they actually received what's called pull notices. And pull notices are essentially any action on a CDL in your motor carrier's fleet. You will immediately receive an electronic notification, typically by email, from the Department of Motor Vehicles, informing you of whatever the speeding violation or collision or fatality is. And so you have to understand that if you don't get that information outright, it's a beautiful thing and it's a gift, because then you get to go take a PMK and presumably they're going to dump all of this information on you about the night before or the morning of. And the defense lawyers that do that are giving you a gift, because it's almost a guaranteed certainty that there are documents that they have not produced. And so you give yourself an opportunity to get 2 bites at the apple, and you go through every single document that's produced, and you identify, based on your knowledge of the FMCSA rules and regulations with respect to what they're supposed to do, the records they're supposed to maintain, where they're supposed to maintain them, and where they are currently, and why they didn't produce any of those documents, or they produced incomplete sets of those documents because they thought that you didn't know that they existed.
Yeah, I mean, it's a gold mine, these driver qualification files. We have listed here the job applications, something as simple as what the driver wrote down in his application. Can be such a gold mine and such a simple way to get to know a driver. What did he write down in his job application? What did the driver omit for one reason or another? Again, this just goes to the very large paper trail that's required to be created and maintained for commercial drivers. Road test certificates, motor vehicle reports, as Dustin mentioned, includes a driver's history. Under the federal rules, the motor carrier is required to investigate a driver's MVR in each of the states where the driver has held a commercial driver's license in the past 3 years. Safety performance histories also required under the federal rules. Accident history, drug and alcohol violations, all of this stuff has to be created and maintained in the carrier's files and held on to for these statutory periods of time. So as Dustin said, it's a huge red flag if the carrier hasn't held on to some of these really routine basic documents, because like, for instance, for drug and alcohol tests and the result of those tests, if the driver has worked at a FMCSA carrier then there's going to be the clearinghouse these days where the carrier can just reach out to the FMCSA clearinghouse and check for, the records of drug and alcohol violations for the driver. But crucially, the carrier still has to reach out to all of the driver's past employers for the prior 3 years. And all of these records in the qualification file, each of them gives you an opportunity to explore something that might have been overlooked by the carrier in the hiring process, or might reflect something that's a theme in your own case. And so, annual reviews, for instance, we list here, every driver has to submit their own list of violations. That includes parking tickets in the last 12 months every year, or, certify that they've had none. And the carriers also have to annually request these MVRs for every state where the driver's listed or licensed. So these are obviously very important records. And, I think a good practical application of it, Dustin, you have a deposition clip of a PMQ talking about how they couldn't find these really basic driver records, right?
Yeah. So I have it queued up. So one of the things that you got to make sure when you are taking a PMQ is you have to probe how evasive they are being at the beginning, okay? And part of that includes a review of what was produced to determine whether they're being forthcoming and providing what they're legally required to maintain in their place of business, or if they're trying to be evasive. So in this case, this was a fatality, and this individual was, let's just say, being a little bit evasive. And so I just wanted to play around and see what he did or did not know or would say he knew. So you are familiar with DOT standards that apply to your tractors and the materials that you are hauling with respect to hazardous materials, is that correct?
Yes, of course.
Okay. Did you have to place a phone call to the Federal Motor Carrier Safety Administration within the first 48 hours, notifying them of the fact that this fatality occurred?
Yes.
And did you do that?
Yes, of course.
Did you prepare a written report within 30 days of the fatality occurring?
Yes, we have a timeline as well as an insurance report.
And those are documents that exist, true?
True.
So tell me about the report that you made to the DOT.
The report to the DOT was made as it was a phone call given to them, stating to them as there was a fatality that occurred on this date. They don't really ask a ton of questions. You just call to report it. That's about it.
Do you have an understanding as to whether that conversation was recorded?
I would estimate it is by the DOT, but I don't fully know if they do, because it doesn't say this conversation is being recorded when you speak to them. So my estimate would be no.
Were you the one that called the DOT?
Yes.
As far as the training that you have on the DOT requirements relating to your company operating, okay, so here you see this guy was 20 years old, and he was running a motor carrier company that had 51 tractors and 54 power units. This is a perfect example of identifying a situation in which there's clearly medical records and items that were in their possession that he just felt he wasn't legally obligated to produce. So after a round of court orders compelling the deposition of this gentleman and the driver of the tractor and responses to discovery, there remained numerous things that had not been produced. And the way that you have to approach it is you have to confront the witness with the actual knowledge of the industry requirements. Because once you start talking about the Federal Motor Carrier Safety Administration regulations, they know that they are in trouble if they did not comply. And that's when they start to at least kind of crack and start to tell the truth. And you can really see how bad the operation is. And I'll go back to this a little later on, but as part of this case, there were requests for admissions that were served, incorporating the safer information. And I'll leave that war story for a little later.
Well, so moving on to other records that we should all be looking for in these trucking cases, hours of service records. Dustin and I have both been in practice long enough to recall when hours of service records were in paper format, believe it or not. So I think it's a true statement that even though there are these electronic logging devices for hours of service records these days, that has not done away with the problem of hours of service violations. The way that the hours of service are cheated or sort of finessed around the edges is just more sophisticated now than it used to be. So just zooming out, the purpose of requiring records about a driver's hours of service is because driver fatigue is a huge problem in the industry and it causes a ton of crashes. And so these records document the driver's duty status. So that's both the driver's hours actually driving, but also off-duty hours. There's on duty but not driving hours. And for the most part these days, these hours are tracked in a FMCSA approved electronic logging device. And the records have to show a driver's duty status for every 24-hour period. And so not only duty status, but location, total miles driven that day. There has to be supporting documentation. It's not like the driver can just say, I drove, X number of miles and was on and off duty during these hours. The federal rules require supporting documentation. So bills of lading, dispatch records, all of this stuff has to be created and maintained. And so you see on the slide, it must be kept for 6 months. So the driver also has to certify the accuracy of these records and submit them within 13 days to the carrier. The carrier is also charged with verifying the accuracy. So as you can imagine, there's lots of occasions throughout this vetting process of the hours of service where somebody might have slipped up, and that gives you an opportunity to, explore the potential liability. Any discrepancy or unexplained period of time in these hours of service records should be considered an immediate red flag. If the driver tells you in deposition that discrepancy was just a mistake, you'll be able to check that statement against the supporting documents, the location information to just sort of determine if it really was a violation or just a mistake. And so, Dustin, you recently asked about a driver's discipline for an hours of service violation, I believe, right?
Yeah, and I had initially planned on talking about that, but the bill of lading is something that I want to bring up first, because for those of the members of the audience who don't know much, if anything, about trucking, I want to make sure you understand a bill of lading is a very important document in the transaction of a motor carrier moving goods from one point to another. It identifies who the motor carrier is, it identifies who the seller of the goods are, and it identifies who the buyer of the goods are, and potentially, if there is a broker involved, it would also identify the broker involved in the transaction. Now, that's a lot of words, but what does that actually mean, right? So when you're trying to hold someone legally liable for something that happens in transit, whether it's a driver that was unfit to be behind the wheel, whether it's a motor carrier that's operating a chameleon carrier type of a business, whether it's you have to keep all of that in the front of your mind, because that is one of the single most important documents to determine every player in the transaction from an overhead view. And ostensibly, before you bring those parties into the case, you obviously would want to have a good faith basis to bring those parties into the case. So the way that I've seen this happen and play out when you're actually litigating a case is you take the PMQ and the driver's depot of the motor carrier as soon as you can in the case. I'm very aggressive with that because it does, by doing so, it prevents the defense from really being able to get all of the records and to really get their head around what's going on and how good or bad of an operation the motor carrier is running. And then you also have a situation where if it is like most transactions, the motor carriers have little to no bargaining power with the people that hire them to haul goods. And when that is the case, and you want to prove a joint venture between those entities, and obviously with everything going on with the preemption, it's kind of a tricky issue with broker liability, and Bobby will get into that more later. But these are things that you have to keep in mind because these are viable potential defendants that you need to get the information to assess whether there is a valid claim to pursue against that person involved in the transaction, and figuring out whether someone is a de facto motor carrier in essence, if there are other parties involved, or if there is, I mean, there are too many scenarios to try and predict what it's going to be because each case is different. But the bottom line is, right, electronic control module data and satellite tracking. Like Bobby said, there's GPS data and speed data that is in every tractor now. And if they're not affirmatively giving you that information, then that's a problem, right? And in the same case I showed you a clip from, same thing happened. They had the data in the tractor, and this tractor was traveling 58 miles an hour before this collision happened. And then here's the thing, instead of preserving the actual telematics data that they were a subscriber to, they decided that they would discontinue their account with that telematics provider when I served them with the lawsuit. 2.5 months after I served them with spoliation of evidence letters. And so at deposition, I was able to establish that they just kept all of this satellite tracking data, did not affirmatively keep it, and instead elected to record their computer screen depicting some of the data from the crash where the 18-wheeler hauling 8,000 gallons of aviation fuel on the 110 freeway flipped over and spilled a few thousand gallons and almost essentially created a bomb that shut down the entire freeway. So when you put that together, you can really get to the bottom of what happened in a case before even the traffic crash report has been finalized, which sometimes takes up to a year in a fatality. So you gotta use these things to your advantage, and you gotta understand what they are. And I will just sit there and I will go onto Google or AI, and I will say, what are the satellite tracking devices that are most popular for motor carriers? And the more you handle these cases, the more familiar you become with the technology that's out there and that's available. And there are now AI assistants with in-cab videos that will watch the driver. And if you look like you're getting drowsy, if you're doing something that's distracted, that will actually give you a verbal correction if the motor carrier has it configured to do so. And that's data that's kept and reflected in a safety rating. And that's stuff that you should be asking for in your discovery. And if you're not asking for it, now you will. And if you're asking for it and you're not getting it, you need to file motions, because that will give you a comprehensive history of the safety rating of that driver, ostensibly for the entire time that that program was in existence in that tracker.
Yeah, great points, Dustin. I don't want to just hew only to the PowerPoint, but I want to make sure I'm staying on track myself. So I'll talk next about this vehicle inspection and maintenance records. So the exact wording from the federal rules is every carrier shall systematically inspect, repair, and maintain all commercial motor vehicles under its control. I didn't want to just list a bunch of the federal rules, but as Dustin said, showing that you know what's required can often help avoid motion practice, because the carrier realizes that you know everything that they're required to maintain, and that they have to give it to you. And so these records include preventative maintenance records. So are all the parts in the truck, in proper condition? It'll also contain these vehicle inspection and maintenance records will also include VIN numbers, the make, the model, all that basic information. Crucially, in a couple of cases, I've seen it helps that the identity of the owner is listed for under the vehicle identification information in these vehicle inspection and maintenance records. So even where the unit is being leased, you'll be able to identify the actual owner. Then there's driver vehicle inspection reports. Drivers are required to complete post-trip vehicle inspections after every trip. They have to list deficiencies. And I guess it's worth mentioning that these days, these maintenance records are typically automatically generated by software, and they include schedules, like, for instance, for preventative maintenance. But, I think an area in deposition that's ripe for discussion is these DVIRs, where a driver is using an app, or on his device or a phone, and it allows them to complete these vehicle inspection reports in a number of seconds. So I think it's worth asking questions to the driver. How long does it take you to complete these, post-trip vehicle inspection reports? Maybe it's mere seconds. I think it's also worth checking with a subject matter expert to see if pressing a couple of buttons on a device really complies with the spirit of the federal rules? You know, is this, in other words, just the floor of what's required, or is it the best practice? And so these are required to be kept for 3 months by the carrier. And, you know, obviously there can be some really big red flags if you're seeing poorly created schedules of maintenance for, you know, preventative maintenance, or obviously if there's something flagged by the driver following a trip and that's not followed up on by the carrier, that can be a big deal. Fuel tax agreement records. I'll just briefly mention this. I've only been able to use it once or twice. They're tax records, really granular data on mileage. In theory, you can use these records to cross-reference hours of service, compliance, and a driver's activity. And then, you know, as Dustin mentioned, the electronic logging device records are huge. One of the things that's not listed here are devices like Dustin mentioned, like Lytix. It's a company that has a device that monitors driver behavior, like lane changes, speed. Really, really helpful to get data from, you know, companies that have these devices that monitor driver behavior. I will say for me personally, it's sometimes really difficult to parse the data that I receive on some of these devices. And so if we don't have an expert yet on the case, a PMQ deposition or a 30B6 always helps me understand what a particular auto-generated report really means, how exactly it was created. Dustin, you had, I think, some comments on the electronic data. I mean, we've already sort of discussed all the various ways.
Yeah, but I want to tie it all together now, because what you have to do is, it's a multi-pronged approach, right? There's written discovery, which we talked about. There's deposition, which we talked about. And there's essentially getting to the finish line, whether that's trying the case or getting it ready, and then the carrier putting a good number on it to get it resolved. And what can you do to help yourself out? Number one, if you don't send a spoliation of evidence letter at the beginning of every single case, please, please, please do yourself a favor and start doing that. You send it to the address that you find on the SAFER system for any parties involved. And that way, you know that you are relying on the information that's up to date as of a couple days beforehand, okay? Number two, you then take the deposition of the PMQ or the 30B6, like Bobby said, and you identify what in the universe of information that we know is out there are they hiding? Because customarily, there's going to be something, and you just have to be thorough in terms of how you approach each deposition to cover each category of information that they're required to maintain, in order for you to then delve into whether there is a spoliation issue. And so when that happens, you already know that you have to have filed motions to compel PMQs, to compel the production of the documents and things that you're seeking. Once you do that, and you get a court order granting that, if the defendant does not comply with the court's order, you then have to get aggressive. And the way you do that is you bring a motion for issue, evidence, or terminating sanctions. Typically, terminating sanctions are obviously a very, very, very drastic remedy. However, when you can establish that there has been affirmative spoliation of evidence in the face of being served with a preservation of evidence letter, putting them on notice of the fact that they're required to basically put any evidence into a litigation hold. When they ignore you and don't do that, you then get to bring a motion for sanctions. And what you do with that is you put the court on notice again of how competent you are, that you are being so diligent, representing your client zealously, that you're not going to let this motor carrier hold on to things that are clearly discoverable and are just going to further help you prove your case as to the concurrent negligence of the driver who most likely made some type of mistake when operating the tractor, as well as the employer for failing to either adequately or reasonably supervise, train, or retain someone. And so that's how you figure this out, is the way to get to the corporate tortfeasor is analyzing each one of the avenues in the electronic logging and the ELDRs. When you then bring a motion, you then put all of the documents that weren't produced, all of the testimony about how they have all those documents, the court orders compelling those documents, and then you wait and see what happens. Because when you are dealing with a defendant that's just not going to listen, you put yourself in a beautiful position to either affirmatively strike their answer because of the spoliation issue and the continued defiance of numerous court orders, but you also are working up an incredible case against the owner of the goods identified on the bill of lading, because they have specific legal obligations in terms of what they're required to do to vet a motor carrier before they hire them to transport goods for them. And going back to the SAFER system, I'm gonna, Bobby, if you don't mind, I want to share a couple requests for admission that I propounded, just to show, we want to take every issue off the table that we can, to the extent that we can, right? And so that means we want to definitively nullify and remove an issue. And so here, let me pull this up. Apologies, there we go. Okay, so I happen to be driving on my way to the airport for a family vacation, and I happen to drive by the defendant in this case. And at this time, the defendant motor carrier had not, we had not had access to the tractor or the trailer or our client's vehicle, because they were still in CHP custody. And we did not know what was going on, but I had suspicions that they were operating what's called a chameleon carrier. And if you look on the side, you see what we discussed earlier, that DOT number and the motor carrier number. And then there will be information that is legally required to be posted on the side of the tractor. Now, then you look at the actual logo on the tractor and you see the name of a motor carrier. And this is why it's so important to be familiar with SAFER, because in this case, the registered owner of the tractor that was involved in this fatality is an entity by the name of Maverick Tank Lines, I should say. And it's operating authority was revoked on May 31st of 2024. Now that happened roughly 6 months before the fatality in this case. And so what you do is you can't not admit the information on this is true and accurate because it's coming from the defendant that's responding to the discovery. And here you get the actual content and the responses, right? And so this admission is functionally an admission that this motor carrier is operating a motor carrier with suspended operating authority from the Department of Transportation, and it's putting the logo for the California licensed motor carrier on the side of the tractor. That's a felony. And I have admissions as to each of these items, admitting that the DOT number is registered to the defendant, that is the suspended entity. And this is all just RFAs that I put together from what was on the Safer website and a picture that I took because I was lucky enough to drive by that tractor on the way to the airport. But when you put all this together, what a judge will do is this case, it is now going to be an admitted liability case. And in all likelihood, those defendants are going to be criminally prosecuted. The federal government is aware of it. The state of California is aware of it. And you just have to do your due diligence to make sure that you inform yourself of every aspect of each entity that is involved in a transaction, because if you do and you pay attention, you're going to find the breadcrumb that unravels. You're going to unravel the entire operation. And when you're representing someone that's catastrophically injured or someone who's lost their kid, and you have an immense responsibility to do right by them. And if you treat your trucking cases like this and you methodically approach and make sure that you are provided with everything that you know exists, that is what you will be able to do right by your client with to get the best outcome for them.
Yeah, it's a great point, Dustin. So in addition, I think what he's saying, in addition to the publicly available information on the Safer website, you should try to be extremely lucky and see the actual motor carrier on the freeway. That's an incredible story. But just to wrap up the electronic logging device discovery, Dustin said it best when he said that modern trucks are basically computers on wheels. Every carrier has a telematics system that records everything from the speed, the location, the braking. And oftentimes the carrier will want to produce a summary report of these telematics. And Dustin mentioned earlier, you want to get the raw data of these electronic logging devices and have it parsed by an expert, because sometimes those summary reports will gloss over conveniently some pretty important points. So this part of the presentation comes with a big caveat. So we should start by noting there's a split in authority in broker liability cases. Jesse Creed, a partner here at Panish, Shea, Ravipudi, recently pointed out a recent case that could significantly limit broker liability. Nonetheless, there are some theories the most obvious being negligent selection of a carrier. So the broker has a duty to competently or select a competent motor carrier on behalf of the shipper. If they didn't do so, or they didn't do their due diligence in looking at the carrier safety statistics, then arguably you have something to hang your hat on in terms of liability. There's cases where you can argue an agency relationship exists. But here, we have a slide that talks about contracts and agreements. Contracts and agreements between a broker and a motor carrier is going to define that relationship. It'll show these load-specific documents. This will show how much control, in some situations, the broker is exerting over the carrier. And so that can sort of help prove this agency relationship. Those communications, often communications between the broker and the carrier, can also show how much control is being exerted by the broker. And so these are all ways to expand your thinking about liability in a trucking case is by bringing in the broker. And so, like with everything that we've discussed, vetting a motor carrier creates a paper trail. And so the broker is going to have all sorts of documentation about everything that they did to ascertain the competency of the carrier. And they're also going to have to produce, the broker is going to have to produce their policies and procedures for vetting carriers. And, if those aren't up to snuff, that's another, ripe area. And so everything listed here, I don't want to go through every single thing, but these are all really important areas of discovery for brokers in these cases. Again, there is a split of authority. Another attorney here at the firm, the famous Andrew Owen, pointed out that the Supreme Court is going to be hearing a case that might resolve the conflicting decisions. So we might have some more clarity on the issue soon. So this is what I mentioned earlier, the load-specific documents. This helps identify who was involved. The dispatch records show control. I'll just move through here. We've had a couple of cases where a broker has some really interesting marketing materials where they seemingly hold themselves out as akin to a motor carrier or handling everything from start to finish. And these kinds of things help show more control than just a neutral middleman connecting a shipper and a carrier. And so this is the case that Jesse Creed pointed out recently, and I don't want to go too much into FAAA preemption. It's not sort of outside the scope of our discovery talk, but it's certainly something to keep an eye on right now. The Supreme Court is going to weigh in on the Montgomery case. But going back to really the thrust of the presentation is the types of discovery in these trucking cases that are so crucial. We really like to review jury instructions at the outset of the case before propounding discovery, because it really shows you the answers to the test before you take the test. And so we use those to craft our active discovery. And then, the staying updated in the trucking cases is really important, as you can see with the broker liability, shifting theories. Sometimes the regulations will change. So it's important to not just sort of cut and paste old discovery and reuse it, because sometimes things will change enough that it needs to be meaningfully, altered. Dash cam, 911 calls. These are other areas that should obviously be explored in discovery. Dustin, you mentioned on the point of just discovery in general that this isn't your typical case. It comes with a really awesome responsibility because there's infrequently a situation where somebody's involved in a trucking case and it's a small injury. So really, there's a huge duty to look at all the publicly available resources at the outset. And then sort of dig a little deeper based on everything that's required by the federal rules.
Yeah, just to echo what Bobby said, I am always perpetually blown away by how much information I can get through a public records request or a FOA. Granted, the FOA requests have been very slow recently, but still, at least with my PRAs in the state of California, I have gotten almost immediate responses. Obviously, they're obligated to respond within 10 days. And if you're not representing the party, then you're going to get less or redacted information or redacted materials or partially redacted. But that said, I try and tell people this. There are cameras on a lot of the highways that are controlled by Caltrans that I think record up to 72 hours after, at which point they disappear forever. So if you are retained on a case after it happens immediately, do yourself a favor and do a public records request act to Caltrans on the highways for any of the cameras in the vicinity where it happened. Also, CHP asking for MBAR footage, the body-worn camera footage, all 911 logs. That will help you identify all the parties that were involved in terms of the first responders, because we always know that there's some type of hearsay issue with a really important statement that was made. And if you don't know who it was that was involved in responding, it's going to make it really hard for you later down the line, and people don't remember things. So when you get that stuff informally for free, basically within 10 days, you already have your liability roadmap most of the time. And then it becomes a game of, are they going to tell me the truth as to what happened based on my reviewing everything that was recorded at this crash? Because anytime law enforcement goes code 3 and they have lights and sirens on, the MBAR camera inside the cruisers automatically records. So that's something that if you have a case involving catastrophic injuries or death, you are certainly going to have a plethora of information because of department policies mandating use of body-worn cameras out in the field now. So again, the more you prepare, and you know, I'm a Wisconsin Badger fan, if you cannot see my clock behind me, but you know, the great John Wooden said, failing to prepare is preparing to fail. And my mentors have always stressed upon me the importance of being prepared. And if you do this stuff, you are going to be able to take on anyone regardless of the size of the firm, regardless of the tactics that they employ, and you're going to do right by your clients.
Well said. Dustin mentioned the Public Records Act. This is a hobby horse of mine. I'd be remiss if I didn't at least add that, you know, we've had a couple of cases. They're not necessarily tractor trailer cases, but sort of adjacent to trucking, tow trucks and medical waste trucking, where the defendant entities have contracts with public entities. And so we've been able to craft Public Records Act requests to obtain contracts and certificates of insurance from, like, for instance, in one case, a public university, in another case from California Highway Patrol, that showed a minimum level of insurance that was required by the public entity to be kept by the defendant carrier. And we got that information for free. And it contradicted in one case what defendant's form interrogatory 4.1 response said. So Public Records Act is, I think, just an amazing use of time and in discovery, and it doesn't cost anything, as Dustin said. Dustin mentioned earlier the idea of preserving evidence. If you get involved in a case early, or even if you're coming in late, it's still worth sending a preservation of evidence letter that's ideally very specific about, emails, trip receipts, engine control module data, telematics, GPS, all of that. So it's really important to send that out early as soon as you get in the case. And we've talked about this. Dustin played a deposition clip already. We like taking multiple PMQ or 30B6 depositions just to verify information that we've received from the defendants and get their own take on their compliance with the federal rules. And so I guess our final takeaways, Dustin mentioned that preparation is a huge part of it. I couldn't agree more with that. I think, at the outset of the case, using the jury instructions and using, publicly available information really helps get off, you get off on the right foot in the discovery process. And, a lot of people say that that's where the case is truly won, is in the discovery process or in deposition. And with that, thank you very much for attending.
This concludes today's presentation. Thank you so much, Bobby and Dustin, for your time, and thank you so much to our audience. Have a great day, everybody.